afternoon, and welcome to the 30-minute employment law series from us attorneys here at Kenny and Sam's. My name is Laura Rasty. I am one of the employment lawyers here. My colleague Michelle is going to introduce herself momentarily, but we are here today to talk about the 5 best steps for employers to arm themselves to defend against discrimination lawsuits. If you have questions during our presentation, please feel free to put them in the chat and we will do our best to answer them if time allows. Of course, if you have questions that we are not able to get to today, feel free to reach out to me and Michelle, and we're happy to help.
Thanks, Laura. Good afternoon, everyone. My name is Michelle De Oliveira. I'm one of the attorneys here in the office, and I have the privilege of working with Laura. We wanted to start off the presentation and the program providing a very brief overview of discrimination laws in a nutshell. So there are both state and federal laws that prohibit discrimination in the workplace, particularly when we're dealing with employees who are in a protected class. If an employee were to bring a lawsuit alleging that the employee was subject to discrimination in the workplace, the employee would have to first establish a prima facie case of discrimination. In order to do that, there are 4 elements that the employee would need to prove and establish so that the employee could proceed and move the discrimination lawsuit ahead. The first prong would be to show that the employee is in a protected class, and we're going to go into that a little bit further, and we'll give a very brief overview of what the protected classes are. The second prong will be showing that the employee was performing the employee's job in a satisfactory manner. The third prong would be to show that the employee suffered an adverse action, and that could be many things. It could be a termination, it could be a demotion, it could be reassignment, it could be a change in shift. It's fact specific in the sense of what exactly the adverse employment action was in that specific situation. The fourth prong would be for the employee to show that the employee was treated less favorably than an employee who was similarly situated, and that other employee who was subject to more favorable treatment was outside of the employee who's bringing the lawsuit, outside of that employee's protected class, or that the employee was replaced by someone also outside of the employee's protected class. Once the employee is able to meet those elements and provide evidence in support of each one of those elements, the burden then shifts to the employer to show that the employer actually had a legitimate business reason for that adverse action that had nothing to do with discrimination. If the employer is able to then establish that burden and produce evidence that the employer had a legitimate business reason for the adverse employment action, and again, it could be a termination, demotion, reassignment, whatever it may be, the burden then shifts back to the employee, and the employee would have to establish and proffer evidence to say that the employer's legitimate business reason is false, and that adverse employment action was actually triggered by discriminatory animus. With that, I'm going to now let Laura go over a little bit about what the protected classes are.
So many of you are probably familiar with many of the protected classes: sex, disability, race, color, national orientation, etc. National origin. I'm not going to go through an exhaustive list of them for you, but there are some here in Massachusetts that I'd like to call out and offer a few, some of them I'd like to offer a few explanatory comments about. So your protected classes include pregnancy, conditions related to pregnancy, marital status, veteran status, uniformed military service. Some others are sexual orientation and gender identity, Those are two separate categories. In a nutshell, to draw a distinction between the two of them, sexual orientation is who somebody is attracted to. Gender identity is how somebody themselves identifies, whether they identify as male, female, non binary, along those lines. Genetic information is another category that gives rise to a lot of questions. The EEOC gives an example of if you know that an employee's grandmother had breast cancer and you decide that you're not going to hire that employee, you're going to terminate that employee or cut their hours so that that person is not subject to health insurance and therefore not a burden on your policy, you're making a decision based on genetic information. Another example is if you know that someone is Ashkenazi Jewish, which is a folks who have a genetic predisposition to Tay-Sachs disease, and you again take action against that person because again, for example, because you fear they're going to draw your health insurance premiums up, so you cut their hours or terminate them to remove them from your insurance policy. That's going to be an adverse action based on genetic information. With that, I'm going to turn it over to Michelle, who's going to talk about our first of the 5 steps in how to best position yourself to both prevent and defend against discrimination lawsuits.
Thanks so much, Laura. The focus of these 5 steps that we're going to be talking about goes back to what we were talking about earlier, specifically the burden that an employer would have to meet and the employer's need to establish that business decisions and potential adverse employment actions are made based on a legitimate business reason. So we need to keep that in the back of our minds as that burden and that proof that the employer would need to establish is the ammunition that we sort of built these 5 steps on. The first of the 5 steps that an employer should utilize to arm itself to defend discrimination lawsuits would be develop policies. Have policies in the workplace that you want your employees to follow and put them in writing. Brainstorm. Think about the policies that you want your employees to follow. Think about discipline policies. What would constitute the basis for termination? Spend time exploring unique situations and scenarios that pertain to each one department or each workplace and figure out what kind of policies would make sense for you as an employer to have. Be clear when you're drafting those policies. One of the things that we often do in our employment practice here at the firm is review handbooks and review policies. We're lawyers, and sometimes we get policies to review that we don't understand, and we have to sort of, peel back and figure out, okay, what is the purpose of this policy? What is the intent? What is this policy designed to communicate to your employees? If we don't understand the policy, there's a potential, likelihood that the employees themselves wouldn't understand the policies either. So it's really important to be clear, to be concise, to write policies that a layperson would be able to understand and follow. At a minimum, employers should have a sexual harassment policy, an anti-discrimination policy, an equal employment opportunity policy, and have your employees sign an acknowledgement form at the end of the handbook or the policies that you're implementing and distributing, so that each one of your employees will acknowledge to the fact that they have read the policy, that they understand the policy, and that the employee will be on notice that a copy of that acknowledgement form will be placed in the personnel records. It's also equally important to have a policy in the handbook to let your employees know that Massachusetts is an at-will state, and therefore, absent an employment agreement, employment with you as the employer would be at an at-will basis, which means that the employment can be terminated at any time with or without notice, so long as the termination is not fueled by discrimination or in violation of public policy. As an employer, when you're drafting policies and thinking about policies, try to avoid incorporating unnecessary promises in the handbook. One of the ways that you can do that is remove the word will or shall from policies and convert that into may. Instead of saying, an example would be, instead of saying employees will be eligible for, think about removing the word will and incorporating the word may instead. And that way you can avoid creating unnecessary promises and expectations in handbooks that oftentimes could lead to confusion. When drafting policies, employers really need to be thinking about the fact that more often than not, if the employee has an underlying disability or a religious belief, that the employer may need to accommodate the religion or religious belief. Why is this important in policies? An example could be in a grooming or dress policy. Oftentimes, the company will want to establish an image into support of a brand that it wants out there in the world. Oftentimes, though, there may be a need to accommodate certain religious beliefs that may impact dress and grooming. For that reason, it's really important to have language in your policies that say, this is the requirement for dress and grooming. And at the very end, there's a little acknowledgement of the fact that employees who need a reasonable accommodation should speak with a manager or should speak with HR. I can't emphasize the importance of communication enough. So communicate with your employees. And one of the ways to communicate policies would be to give them notice. Have these policies in writing. If you update a policy, and one of the things that we should, that I'll say here as well is that employment laws change so often, and it's really important for employers to conduct reviews of their handbooks and update policies as needed. When you do that, it's also equally important to notify your employees to ensure that all employees are getting notice of what the policies are. And with that, I'm going to turn it over to Laura, and she'll talk about the importance of training management personnel, which is our step number 2.
Thanks, Michelle. So once you have a policy, you want to make sure that both your managers and your HR personnel know about it. And just to underline Michelle's point about how important it is to have a policy, a lot of times when you get an MCAD charge, for example, a good policy is usually exhibit number 1 for an employer in responding to those charges. So keep that in mind when you're developing your policies. Now, it's also, in addition to having a good policy, you need to make sure that your managers and your HR know about those policies and know the implications of those policies and how to carry them out. So obviously, you want to train your managers in as to what your sexual harassment policy is, what your EEO policy is, what, using the example that Michelle just said, what your grooming and dress policy is. They need to understand those policies, and your managers need to have their eyes open in the workplace to recognize potential violations or infractions of those policies, or recognize circumstances that might give rise to that. That includes monitoring employee behavior and addressing employee behavior when it's in violation of those policies, or if they're not sure if the employee behavior is in violation of those policies, that they know who to go to ask questions to make sure that those policies are carried out and enforced. So you want to train your managers on the policy, let them know what their obligations are with regard to your workforce, let them know, if they see an infraction of a policy, or again, if they're unsure and it needs to be escalated, that they know who to go to for advice on that. You want to I can't emphasize enough that you want to make sure that your managers are armed with enough knowledge to recognize these violations, to deal with them, or to raise them up the flagpole. Among the issues to keep in mind here as well is that there is a duty to investigate, particularly with harassment and discrimination claims. When your manager, so you want to train your managers on those policies. If they see a violation of those policies, they need to bring it to HR, and HR should commence a prompt, thorough, and impartial investigation into those allegations. There is an obligation on employers to stop any discrimination or harassment in the workplace. So again, you want to make sure that your boots on the ground, your managers who are out there are able to recognize these problems and address them when they arise. You want to make sure that you take remedial action, not just at the conclusion of your investigation, but during the course of the investigation as well. There are times when people will make a complaint against a coworker, and they're forced to sit next to that coworker who they've now alleged has harassed them during the course of the investigation. In those circumstances, what you want to do is you want to try to separate those folks. If it's a matter of putting them on different shifts, if it's a matter of moving where they sit in the office so they no longer encounter each other. Another potential step is you may want to, depending on the severity of the complaint, you may want to tell the alleged wrongdoer that you need to conduct an investigation until the investigation is concluded, that they will be, asked not to come to the workplace any longer until that investigation is concluded. So you want to keep those steps in mind. But perhaps one of the most important principles in this regard is that when an employee comes to you or raises a concern to a manager or an employer of discrimination or harassment or inappropriate treatment, listen. You want to listen to it. You don't react. Take it in. Give a moment to digest it. Digest the information, and then respond. You don't want to react and say, well, that can't possibly be the case. We have a policy against that, or that can't possibly be the case. Elizabeth would never do that. You need to listen to that employee. You need to realize that they're raising a sincere concern, and you need to take steps to address it in a way consistent with your policy. This leads into the next reason as to why it is extraordinarily important to train your manager, and that is that you want to make sure that your employees are treated consistently. And I will let Michelle talk some more about that.
Thanks so much, Laura. So the third step is exactly what Laura just said: consistency. Be consistent in the application of company policy and in the way in which you are treating employees, in the way in which you're disciplining employees, in personnel decisions and actions as a whole. Why is it so important? The reason it's so important is that there's case law and decisions that have held that certain actions may constitute and may be evidence of discriminatory animus, including disparate treatment, which is, what is disparate treatment? Disparate treatment is just differential treatment. If you are treating an employee different as compared to another employee, and we're going to talk a little bit more about that, that could be, in a discrimination lawsuit, evidence of discriminatory animus. One of the ways that you as an employer can avoid that altogether is if you don't subject employees to differential and disparate treatment. Treat your employees the same. Apply your policies in a way that is consistent so you can try, to the extent that you can, nip that concern in the bud and not have a concern about an allegation or evidence of disparate treatment. There's also case law that talks about deviation from policies and practices as evidence of discriminatory animus. So again, more so, the reason that it's important to not deviate from your policies or practices. Even if you have an employee that is a favorite employee or a long-term employee, if you're dealing with an employee in a protected class and another employee who is outside of a protected class, deviation from practices, even if it's unintentional, even if it's something that you're doing, that has nothing to do with discrimination, it could be construed as discrimination, or at least an employee who thinks that they're being discriminated against because of their religion or because of their sex. They could use that information and they could perceive it and construe it as discrimination. Additional evidence of discriminatory animus recognized by case law and decisions includes statistical evidence. And again, statistical evidence oftentimes includes statistical evidence when you're comparing the way in which employees are treated. You're comparing termination trends, and you're figuring out, okay, how many employees in a protected class were terminated in the past year or in this past layoff as compared to employees who are not in a protected class. And there's also case law that supports the notion of uncontrolled subjectivity in personnel decisions can also be evidence of discriminatory animus. For that reason, having policies in place that will outline the steps that an employer needs to take in the event of, a personnel matter, for example, discipline or abuse of an attendance policy or excessive tardiness, things of that sort, you may be able to avoid the risk that an employee will point the finger at you and say, the decision to demote me or the decision to transfer me had nothing to do with a policy or practice. It was just that was your subjective decision to do that. So again, these are reasons why it is so important to have policies be consistent and handle personnel matters consistently. Another thing that I think we all know, people are watching, and oftentimes employees are paying attention to what happens around them, and employees will notice, or I shouldn't say will, I should say may, employees may notice differences in treatment, and they can start making comparisons between themselves and other employees. And again, honest mistakes or honest omissions or decisions that an employer makes that it really has nothing to do with discrimination. If you have an employee in a protected class who all of a sudden is looking around him and is noticing that coworkers and peers are getting better or more favorable treatment of some sort, and then all of a sudden that employee is maybe terminated or demoted or laid off, all of those pieces of evidence and information could fuel and support a potential discrimination case. It's important to note we're talking about consistency and we're talking about, similar and differential treatment. It's really important to note that there may very well be situations in which an employer will need to treat two employees differently. So there's no need to think that every single employee needs to be treated the same way. When we're talking about differential treatment and the need for employees to be treated the same way, the focus is really on employees who are similarly situated. So for example, if you look within a department or within an organization, if you're trying to figure out who is similarly situated, generally, if you have folks on an executive level, those folks would be similarly situated. If you have administrative support staff, those folks would be similarly situated. Your store managers or your department heads, those folks would be similarly situated. But the case law is clear that if you make a comparison between an administrative assistant and a CEO or a CFO, those two classes of employees would not be similarly situated. So we're not trying to say that every single employee needs to be treated the same. And there may be situations in which differential treatment is warranted. And again, the focus and the question is, are the employees that you're treating differently similarly situated or not? And with that, I will transfer it over to Laura.
Thanks, Michelle. We had one question come in that I want to try to answer somewhat briefly. It's actually a topic that will deserve much more than the time I'm going to be able to give it. But what constitutes a thorough investigation? Essentially, you want to identify an impartial investigator who is going to conduct interviews and collect evidence. Interviews of the complainant, interviews of the alleged wrongdoers, and any witnesses who are identified by the results of those interviews. And then someone who is going to assess the interviews, assess the evidence, and make a conclusion as to whether there has been a violation of company policy. You do not want your investigator determining that sexual harassment has occurred or there has been religious discrimination, because that will come back to haunt you when and if you get a discrimination lawsuit. So that's just it in a nutshell. It's a topic that deserves the more than I'm giving it, and perhaps we can take it under advisement for a future one of these series. So, um, in addition, but that does lead me into another topic, which is you do want to make sure that any investigation findings are written up in a report. So just like that, you want to make sure that your documentation regarding employee performance is both contemporaneous and honest. By contemporaneous, we mean create a record at the time the event happens. If you issue a written warning because somebody is late one day, you want to make sure that that written warning happened at that time, not 6 months later. Um, the reason why this can be potentially problematic is that if an employee may point to it later as saying, "Oh, well, I was late on September 1st, and then I complained about alleged race discrimination in November, and then all of a sudden December you now decide to write me up for something that happened 3 months earlier." That's going to be looked at with askance by the employee and the courts. The other issue is that you want to make sure that your employees are honest, particularly with performance reviews. It's very difficult oftentimes for managers to do that because number one, they don't want to upset their employees, and number one, too, they're pressed for time. So they'll just go through the document and they'll check, great, 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 great. If that's not honest, it's going to be difficult later for you to say, well, I terminated Bob because his performance was substandard. But if all you have in his file are performance evaluations that his supervisor filled out that just said what a great employee Bob is, that's going to call into question the legitimacy of that reason, the non-discriminatory reason you gave for terminating Bob. One last thing, you want to make sure just a few best practices when you're documenting things. Have the employee name on the document, have the date on the document, have page numbers on that document. If it requires an employee's signature and the employee refuses to sign, note that and have the name of the manager on that document. And if it's a performance improvement plan that requires follow-up in a certain amount of days, make sure that that happens, or use the language that Michelle said earlier that gives you some flexibility. We may follow up. We will endeavor to follow up. And with that, I will let Michelle cover our last step, which is personnel records.
All right, so step number 5 relates to what Laura was talking about a minute ago, which is, documenting performance issues in real time and being honest in those communications. Once those communications are created, in Massachusetts, we have a personnel record statute. And so as part of this presentation, step number 5 to defend yourselves and to arm yourselves to defend against a discrimination lawsuit would be to ensure that you have a complete set of documents that were created in real time about performance issues that will eventually go into the personnel records. Why is this recommended? Because it's actually required. It's mandatory in Massachusetts law. It's chapter 145, section 52C. And that statute imposes an affirmative obligation on employers to notify all employees within 10 days of placing any information in the personnel records that, to the extent the information has been, or may be used to impact the employee's qualifications for performance. So really anything that relates to terms and conditions of employment, to potential discipline, information that may support a termination decision, all of that information in those documents need to be placed in the personnel records. Not only do they need to be placed in the personnel records, but then on top of that, employers need to go to take an extra step and notify employees within 10 days of putting those documents in the personnel records. In Massachusetts, we had a recent court decision issued, Meehan versus Medical Information Technology, which actually recognized that employees in Massachusetts have a statutory right of rebuttal, which is a legally guaranteed right in the statute. So now we have a court decision that has said this, but all along we have known that the personnel record statute also states that once the employer includes the information in the personnel records, gives the employee notice of it, the employee has an opportunity to rebut the information or prepare some sort of response to that information. And then the response also needs to be placed in the personnel records. And this is really important. And I'll give a quick example. Oftentimes there termination decisions arise due to poor performance. If we're representing an employee who comes to us and says that the employee was terminated for poor performance, the first thing we want to do is we want to see what's in the file. What is in the personnel records to support that poor performance reason for the termination? If an employee is terminated for cause, we want to know what is in the file. What kind of documents exist in the employee's file that would support the for cause termination decision, as opposed to the employee thinking that the real reason for the termination was something else. It had nothing to do with performance or with whatever the reason for the termination given at the time. And so with that, we're going to conclude. I'm going to turn it over to Laura, but if anyone has questions or thoughts, we're happy to be resources, and you can ask any questions at any point.
Great, thanks, Michelle. Yes, we are aware that we threw a lot of information at you this afternoon, and we're aware that we're running a little bit over. So if you have any questions about any of the information that we've presented today, please feel free to reach out to either Michelle or I. We're certainly happy to help. I want to remind everyone that this coming Thursday at 7:30 in the morning, that our firm's 30-minute construction law series is going to be presented with Drew Colby and Matt Welnicki. And on April 7th, again at noon, please join us for the next in our series of employment law webinars, where we are going to talk about employee classification and why it matters. Thanks very much for joining us this afternoon, and we hope you all have a good day.